Alrighty, so we are going to dive into defeasible fees in property law. Okay, so as you know, defeasible fees is just another aspect in estates in property law. Okay, so my previous video, as I said, I'm going to divide estates into multiple videos because it is a very complicated subject. Therefore, we're going to talk about future interest in regards to defeasible fees in this video. And then for the next video, I'll get into contingent remainders and vested remainders. Okay, so let's dive into exactly what defeasible fees mean. But real quick, let's just go through a very quick review because understanding reversion and understanding remainder will be critical for understanding defeasible fees. Okay, so let's go into reversion real quick. So reversion means if upon expiration of A's interest, the property will revert back to O, the grantor. An example of this is O conveys gray acre to A for life. So as you know through this example, O gave a life estate to A. So when A dies, it will revert back to O. That's the way this example works. So we get into remainder. Remainder means that if upon expiration of A's interest, the property will go to a third party, B. An example of this is O conveys Blackacre to A for 10 years, then to B for life. So this means that the moment A's interest is over, the 10 years is over, it will go to B. That'll be the third party who will take Blackacre the moment the 10 years are up. So we go to our outline of the defeasible fees. And we have three things that we need to understand. Fee simple determinable, fee simple subject to a contingent subsequent, and lastly, fee simple subject to an executory interest. So understanding these three things will be absolutely critical in doing well in your class in regards to understanding this concept. So fee simple determinable really boils down to this. This is the general definition they need to understand. This is a fee simple absolute, but for a provision in the transfer document that causes the estate to automatically end based on an event or non-event happening. Okay, so this will create a possibility of reverter to the grantor that will happen right away, assuming that that event or non-event does happen. Okay, an example here is O, the grantor, gives the land to A for life, so as long as A uses the property for school purposes. Okay, so this means that A has a life estate, right? But there's a condition on this life estate. It will have to use the property only for school purposes. Okay, so if A used the property, let's say for bar purposes, then it'll automatically revert back to the grantor because A violated that condition that was on the document. Okay, so O would have the property right back from A, basically a reverter, right? So as we discussed from the beginning, it would be a reversion back to O. Typical words used in fee simple determinable will be so as long as, unless, until, enduring. You see that terminology, then you will know automatically that is a fee simple determinable. And also you need to understand that, hey, the moment A violates that condition, it'll automatically go back to O. Fee simple subject to a condition subsequent boils down to this general definition. So this creates a right of re-entry in the grantor, such that the grantor may retake the property from the transferee, but it does not happen automatically. It creates the option to do so. So only the grantor and his or her heirs, assuming that the grantor dies, can retake the property from the transferee, which is a future interest in the land. Okay, so the usual language used in this situation would be provided that, but if, and on a condition that. An example of this is O conveys Brownacre to A for 20 years on the condition that A uses it for search purposes only. Okay, so A gives Brownacre to A for 20 years, right? As we can see, that's very clear. However, there's a condition subsequent here because A can only use that property for church purposes only for 20 years, right? So the moment A stops using that property for church purposes only and opens up a restaurant on Brown Acre and uses it for restaurant purposes only, O will have a possibility of going back into the property and retaking the land. So pretty much it's an option to do so. Okay, so A can have the property for a full 20 years and use it for restaurant purposes only. However, the moment O finds out, O has the option to do so. So it doesn't automatically happen like feasible terminal. Okay, O simply has the option to do so. So whenever O feels like it, O can do that the moment A violates the condition subsequent here. Fee simple subject to an executory limitation really comes down to the fact that, hey, the grantor transferred a fee simple absolute to A, the transferee, and at the same time created a third party interest to another person involved in that instrument. Okay, so we have O conveying the property to A and is giving a future interest to B, a third person in the same instrument. And that future interest is called an executory interest. So this transfer will happen right away, unlike fee simple subject to a condition subsequent, because the moment A violates that condition, it will automatically go to B. Or in a situation like our example right here, once the 20 years is up, it will go to B, right? Because B technically still has an executory interest because B has a future interest in this situation, right? So let's read our example here. O conveys Caney land to A for 20 years, but if A sells liquor on the property, then to B. So let's say that A does sell liquor on that property, does sell liquor on Caney land before the 20 years is up. Then it'll automatically go to B because A violated that condition, right? And so in this case, B would technically have an executory interest. So let's talk about shifting executory interest versus springing executory interest. This is very important for you to know. So shifting executory interest is an executory interest that divests the interest of another transferee. In other words, it cuts short a prior estate created by the same conveyance. Okay, an example of a shifting executory interest is O, the grantor, conveys 30 acres of land to A and his heirs, but if B returns to Japan, then to B and his heirs. So O is giving A 30 acres of land on the condition that if B does in fact return to Japan, then B will divest A from that land, and A and his heirs will have complete possessory control over that property. So springing executory interest boils down to an executory interest that follows a gap in time in possession or divests the estate of the transferor. An example of this is O conveys Whiteacre to A for life, and 1 year later, after A's death, to B. So O gives Whiteacre to A for life. So 1 year later, which is the gap in time, right, the gap in possession, it will go to B once A dies. Okay, so basically once A dies, the A for life, as you can see in this example, once A dies, it will revert back to O. And then once 1 year passes, it will go to B. That is a springing executory interest here. So you have any questions, comment below. Okay, any requests on criminal law, torts, contract, civil procedure, and property law, comment below and let me know. I will answer any of your questions. Thank you.